Hello everyone. So welcome to this discussion session on the Hindu. This is 26th of February 2026 and here we are going to start our discussion. So first thing is that India stands firmly with Israel. That is what Modi tells Knesset. Okay, so Knesset is basically the name of the Israel's parliament. Okay, so you see, Prime Minister Modi is on 2 day visit uh, to Israel. Okay, so recently he has addressed. Yesterday he has addressed the Parliament of Israel. Okay, now then not much things from the first chapter. Now let us see the editorial part. So editorial is about the balancing faith, dignity, and constitutional rights. Okay, so it is written by a person who is advocate practicing in Madras High Court. Okay, we'll try to do this. Okay, and before that, let us just check what are things which can be discussed today. Okay, what are Indian firms training LLMs? Okay, so AI basically, so Servom AI, which has been lots of news. Okay, so Servom AI basically is indigenous AI, so that is what we need to discuss today. Okay, so let us jump to the discussion on the editorial. Okay, so balancing faith, dignity, and constitutional rights. So this is the title. Let us dive into this. So when a judge bench of the Supreme Court of India delivered its verdict in September 2018 in Indian Young Lawyers Association versus State of Kerala, opening the doors of Kerala's Sabrimala temple to women of all ages, uh, it provoked a range of reactions. Okay, so you all know that the Sabrimala temple, which is in Kerala, was earlier not open to women for the worship. Okay, however, in 2018, Supreme Court ruled that the doors of the Sabrimala temple must be open for all all the women of all ages. Okay, so that is what is the thing. Okay, it provoked a range of reactions, and there were protests across the country, especially in Kerala, where many believed that the court had overlooked and even disrespected religious creed. Others saw Others saw the verdict as transformative, as outlining a vision that lived the Constitution. Now, close a decade later, the court will hear final arguments on review petition that seek to overturn the earlier verdict and the law it set down. Sorry, it laid down. Okay, so now right now what is happening? So the Supreme Court is going to hear the final arguments on the review petition. Okay, but that is seeking to overturn the earlier verdict and the law laid it down. Okay, so the Supreme Court, what it has in 2018 ruled that the Sabrimala temple must be open for all women of all ages, is going to be reviewed by the Honorable Supreme Court of India. Okay, because the petitioners have filed cases arguing that the earlier decision of the Supreme Court allowing all the women of all ages should be cancelled, and the law as well. Okay, so that is what is going to be. So let us see what the outcome is going to come, and before that, let us see the further part of the this editorial. Okay, so opinion, dissent, and turning point. So let us see. The original ruling was delivered through four is to one majority. Okay, so basically the original ruling was delivered by 4:1 majority, which means that there were five members of that ruling bench. Okay, and out of five, four were in favor of giving approval to giving approval for the worship of all women at Sabrimala temple. Okay, however, one opposed that. So so the ruling was passed by 4:1, allowing all women to worship. Okay, there was an opinion from the Chief Justice of India, C.J. Deepak Mishra, to which Justice A.M. Khanwilkar joined. There were separate concurring opinions from Justices Rohinton Nariman and D.Y. Chandrachud, and a notable dissent from Justice Indu Malhotra. But despite the cleavage in the rationales adopted, the majority's findings were clear. First, the court ruled that the devotees of Lord Ayappa did not constitute a separate religious denomination. Second, that the war enforced on women between the age of 10 to 50 from entering the temple violated the rights of women of freedom of religion. And third, the Rule 3B of the Kerala Hindu Places of Public Worship Rules 1965, on which a ban was grounded, violated not only the constitution but also Section 3 of its parent law, which promised free access to temples for all classes of Hindus. In her dissenting opinion, Justice Malhotra found, among other things, that fundamental rights in a secular polity needed harmonizing, that a genuine doctrine of equality cannot override the collective rights of individuals to practice their faith in line with their customs and ideals. She also found that, as a matter of custom, women of a certain age had been excluded from the temple's precincts, and this constituted a non-derogable essential religious practice. The later finding represented the central axis on which the case turned. The Constitution recognizes both the freedom of religion as an individual right and rights of religious denominations to manage their own affairs in matters of religion. Sorry. Both rights are subject to public order, morality and health, and in the case of an individual right to freedom, also to other fundamental rights. Okay, so constitution recognizes what you have freedom of religion as an individual right, and also the rights of religious denomination to manage their own affairs in matters of religion. Okay, however, things that you must remember that these rights sorry, these rights are not absolute, which means that there are certain restrictions on account of public order, morality, and health. Okay, so that is the thing. Next, balancing communitarian interest with individual conscience has long plagued our jurisprudence. Over the years, when it has been called a resolve tensions of this kind, the court has used a test that has allowed it to virtually sit in theological judgment over religious practice. That is, it examines and arrives at a factual conclusion on whether a practice in question is essential to the religion or not. This has meant that the court has effectively determined not only those areas where it might be constitutionally justifiable for the state to intervene, but also has also determined what kinds of practices are deserving of constitutional protection in the first place. Now, for example, in Shastri Yagna Puri Sachi versus Muldas Budradas Vaisya 1966 CGI PP Gajendra Gadkar deducted what was essential to the followers of Swami Narayan sect through selective references to Hindu texts without so much asking what the conscience of the followers in fact dictated. In one page, he even concluded that the genesis of the suit is founded on superstition, ignorance, and complete misunderstanding of true teachings of Hindu religion. A court sitting as a moral arbitrator on religion ought to be an anathema to secularism. Therefore, that we need a theory that departs from the essential religious practices test ought to be beyond doubt. As Justice Chandrachud wrote in his judgment in Indian Young Lawyers Association, the rationale for allowing a religious community to define what constitutes an essential aspect of its religion is to protect the autonomy of religions and religious denominations. Protecting that autonomy enhances the liberal values of the Constitution. By hinting upon doctrine issues of what does or what does not constitute an essential part of religion, the court has, as necessary consequence, be required to adopt a religious mentor. The test also suffers from other practical limitations. It calls upon a constitutional order to arrive at fully fleshed out factual findings without allowing parties to lead oral evidence or subject witnesses to cross examination. What is more, the guide also does not offer a clear solution for what is really an obvious problem. What must a court do when a practice it finds essential to religion also undermines or is inimical to and the dignity of individuals? On an anti-exclusion test, on an anti on an anti-exclusion test, it is for this reason that Justice Chandrachud proposed an anti-exclusion test. In this formulation, this norm would allow for due deference to be shown to each religious group to determine for themselves that doctrines and tenets to follow. At the same time, should any such practice exclude an individual in a manner which impairs their or hampers their access to basic goods, the freedom of religion must give way to the overarching values of a liberal constitution. Now, at a doctrinal level, the test is not beyond complications. At first glance, it might well seem to replicate some of the difficulties that have long beleaguered the essential religious practices doctrine. To determine whether a particular form of exclusion impairs dignity or access to basic goods, a court must inevitably engage with the meaning and purpose of practice in question. Such an inquiry cannot be carried out in a vacuum. It may have an impact on the normative content of faith itself, but where it differs is that the investigation remains grounded in constitutional terms rather than theological ones, a crucial distinction. In other words, the anti-exclusion test does not ask whether a practice is essential to religion. It asks whether the consequences of a practice are compatible with the Constitution's guarantees of equal treatment and protection. This distinction is crucial. Under the essential religious practices test, constitutional protection turns on whether a court sees a practice as critical to the exercise of faith. By contrast, under the anti-exclusion test, a court accepts as a starting point the autonomy of religious groups to define their own tenets. It only intervenes to ensure that the exercise of that liberty does not lead to a systematic exclusion of individuals from places or benefits that are integral to their ability to lead a life of dignity. When the nine bench judge begins its hearing, it will have the opportunity to reflect on the broader architecture of India's religious freedom clauses. The principles it lays down will have a bearing not only on Sabrimala dispute but also on a host of other controversies as well, including the rights of the Bodhi Bohra community members against excommunication and of Parsi women to continue the practice of Zoroastrian faith upon marrying outside the religion. As the framers of the constitution recognize religion and social life are inextricably connected in India. This makes it impossible for courts to remain entirely indifferent to the real life consequences of religious practice. The anti exclusion text acknowledges that faith must remain autonomous in its own domain, but its outward exercise sorry, comport with the constitutional commitment to equal moral membership. Now, if the individual is to remain the basic unit of constitutional concern, communitarian claims cannot override a person's right to access spaces and institutions that shape civic life. In placing dignity at the heart of the inquiry, the anti-exclusion test offers a framework that remains truest to the constitutional native promise by protecting belief without licensing discrimination in its name. Okay, so that's all for this discussion. Now let us move to other thing. Okay, unpacking the myth of safe water in India. Not important for us. See, not everything are important for us. Okay, so what is important is this one. How are Indian farms training LLMs? LLM means large language models. Okay, so basically, here Why is training a large language model on Indian soil with Indian capital a challenge? How has the India AI mission subsidized efforts to conduct training in India? Why is a mixture of experts architecture inexpensive than other comparable models? Now let us see. At the India at the AI Impact Summit, the Bangalore-based startup Servan AI released two large language models, which are the foundation for AI systems that power services like Google Gemini and OpenAI's ChatGPT. The two models were trained on 35 billion and 105 billion parameters respectively, which were less power and compute intensive than comparable models, while demonstrating improvements over other models in Indian languages. Pratyush Kumar, a Servant co-founder, said. How are LLMs trained? LLMs are trained and operated on cluster of processing units. Processing units. The combined cost of graphics producing units and the electricity needed to run them long enough to train a model run into millions of dollars. The grist for this mill is data largely scrapped from the internet, where English, European languages, and East Asian languages like Korean and Japanese are more easily represented than Indian languages. This creates a twofold challenge for training an LLM on Indian soil with Indian capital. For one thing, with scarce data sources, many LLMs either perform worse when operating on Indian languages or burn more tokens on inference to translate sentences into English and translating responses back to perform better. Uh, since machine translation has improved dramatically for Indian languages, this remains the gold standard for many LLMs. Secondly, since capital is also scarce, efforts to train an LLM by Indian firms targeting Indian users can be challenging, especially if there is no immediate business use case for doing so. Using translations as a fulcrum can be a challenge for developers who want to leverage local LLMs like Servam's 35 billion parameter model, which was shown off in demo during the summit's research symposium, working on a feature phone where suboptimal performance in Indian languages can impact adoption and quality of performance. Has there been government support? The India AI mission has subsidized efforts to conduct training in India by commissioning over 33,000 GPUs in data centers operated by Indian firms like Yuta, allowing researchers and startups to run training and inference workloads at relatively nominal fee. The government gave Servom access to 4,096 GPUs from its common compute cluster, and the subsidy so far is estimated at almost 100 crore. The the bill of materials for this cluster is 246 crore, though these GPUs can probably continue to be used by others. The Ministry of Electronics and Information Technology has encouraged domestic LLM development for many reasons. The main one is belief that the foreign developed LLM cannot possibly find the capabilities or the business case to develop the capacity to work well with Indian languages. Additionally, increasing talent that can train LLMs has been seen as important to foster the Indian AI ecosystem. SS Sarvam's announcement of its two models is a significant development in India's on quest to develop a powerful and relatively inexpensive LLM. When China's DeepSeek developed its R1 R1 LLM, the entire AI industry quickly adopted its techniques as it saved on cost for training and inference without compromising output quality. The government has set to spark a similar cost advantage. Mr. Kumar of Sarvan said that the LLM was trained from scratch and that the model would be made open source. However, while it has been made available on an app named Indus, it is not available on platform like Hugging Face, making it difficult for outside experts to scrutinize the claims the firm has made. What is the Ministry of MOE architecture? A key breakthrough for AI models seeking to function locally was the mixture of experts, MOE architecture. When the first LLM trained on hundreds of billions or even over a trillion parameters were launched, inference was typically run by activating all parameters, making queries expensive. But an MOE model only activates a fraction of the overall parameters of a model, making it run faster and also consume a lower level of computing resources. Even 105 billion parameters server acknowledges is significantly smaller than the frontier models powering global consumer data applications today, and consumer chat applications today. And the firm says it is intentionally focused on accuracy, usefulness, efficiency, and alignment for the Indian context before training bigger foundation models. As such, the answers are not as in-depth as response from paid versions of Gemini or ChatGPT. That part will come later, Sabam says, when it has the necessary investment to put money into a larger training run. Another LLM developed and trained on the common compute cluster was Bharat Jain. Bharat Jain, the IT Bombay incumbent firm that was able to train a multilingual 17 billion parameter model. That model, the firm says, is for the use in sectors like education, healthcare. Ganani AI dot Ganani AI, another firm launched a small text-to-speech model. Good. What is the carbon capture utilization technology? I think we have already discussed this one. Anyway, we are going to just see the gist. Okay, so the carbon capture and utilization refers to a set of technology that capture carbon dioxide emissions from industrial sources or directly from the air and convert them into useful products. Okay, it has consistently been the world's third largest emitter of CO2. Okay, in the framework, risk in scaling CCU in India is a cost competitiveness. Capturing, purifying, and converting CO2 is energy intensive and expensive. Okay, I hope that this much thing is clear now. So those things which are important for our examination perspective, we have been able to complete from the Hindu. Okay, so the Indian Express, uh, if time permit, then we will do. Otherwise, we will not do the discussion of the Indian Express because we have limited time, and you all know that the prelims is approaching fast. So thank you very much.